Well, thank you all for joining us this is part of our monthly events at 4:30. We try to do it the first Wednesday of every month, although for different reasons it walks around a little bit. But we're delighted to have all of you here, and we're delighted with how successful this event has been, and it's been a lot of fun, I think, and really enlightening. We always close the year with this event, which is a year review wrap-up, to try to look at all things that have happened in the past bit. Obviously, it's a river that keeps flowing. We're not done yet. There's always constantly keeping changes, but we're going to have 4 presentations, and time permitting 5 on me. Professor Wagner will be talking about what's going on in patent law. Professor Huffelkamp will talk about antitrust and about the Democratic proposals for changes to the antitrust law, because people seem to be. It's amazing how Google and Silicon Valley and Facebook used to be the darlings of all of the press and society, and now they aren't anything but. Professor Dahl will then talk about trademark and some of the interrelated developments there. Professor Bogdanich will talk about copyright, and time permitting, I may say a few words about privacy and the ongoing challenges going on there. Without further ado, let's work.
All right. All right, thanks everybody for coming. It's always good to be here. Yeah. All right, so I'm going to talk about patents primarily, and look forward to chatting with everybody in the Q&A about this. So I'm primarily focusing on some of the Supreme Court cases, but also talking more generally about some what I think is one of the most interesting and important things happening in the patent system in the last decade or so going on now. So we've had a couple of, well, we've had one case that's out so far this year that we talked about last fall in our preview. Oh look, my emojis didn't come through, but so this is the Helsin case. So the question on the Helsin case was, did the American Invents Act, the revisions to Section 102 in the American Invents Act, change the meaning of on sale, making non-disclosing third-party sales no longer barred? The traditional rule for the last several decades in the patent law has been that it doesn't matter whether a sale is disclosing the invention or not, as long as the sale is of the invention and prior to the critical date, it's a bar for 102 purposes. Now, they tweaked the language in Section 102 when they did the American Invents Act, and it said, they added a phrase saying, and otherwise available to the public. And the argument that Helsin made was that addition of that language, otherwise available to the public, changed the meaning of on sale for purposes of third-party secret sales. The holding was, the Federal Circuit said, that's ridiculous. There's no evidence in the statutory history or anything else, frankly, to suggest that there was intended to be some change in what counts as a sale, bar and sale, what doesn't count as a bar and sale, and held that it was still a bar. The Supreme Court took the case for reasons that mystified everybody, basically, in patent law, because it seemed like a very simple and straightforward matter of statutory construction, but I guess they need the work, so they took the case and basically said the Federal Circuit had it right. Those of you who study the Supreme Court and patent law know they did not. In fact, they say the Federal Circuit had it right. What they said is, we, the Supreme Court, had it right all along. We're just going to ignore that the Federal Circuit had said that before. Justice Thomas wrote a unanimous opinion. This will have precisely zero impact on the patent law because everything continues as everybody knew and expected it to happen. And again, the big mystery is why the court thought this was a case that was interesting enough to take. Side note, this was argued on December 3rd, and the opinion was issued on the first opportunity in January, which is one of the fastest turnarounds for a full opinion in recent memory. So Justice Thomas's clerks worked over the holiday break to answer the answer that the Federal Circuit had given for the last 2 decades. So that's the Helsin case, and the one case we have so far. And there's another case that's pending, actually a couple cases as well. This is pending, and this is return mail versus the Postal Service, right? And this is again dealing with the American Invents Act. You might be noticing a theme here. Basically, the American Invents Act of 2011 has a number of, shall we say, ambiguities in the textual language. Not the finest example of statutory drafting, and it's caused a lot of litigation, and it's going to occupy the courts for years and years trying to clean some of this up. So one of the questions is, for purposes of the new inter partes review system, whereby anybody can petition to have a patent that's currently granted be reviewed under the IPR rules, does the government count? The government can be sued for patent infringement, and so the Postal Service is being sued here for patent infringement, and they say, or at least potentially sued for patent infringement. Actually, I think they were sued. And what they did was essentially what any other private defendant would do. They went to the patent office and filed a petition to have the patent reviewed under the IPR regime. And the question in return mail says, well, you can't do that because the statutory language says a person must file the petition for IPR review. So the case is pending. The argument was February 19th. The argument, and this seems sort of dumb, but it was a very interesting argument. The justices sort of had a lot of concerns on both sides, right? One set of arguments is, well, why would Congress leave out the federal agencies because they get sued for patent infringement a fair amount of the time, and if part of the overall goal of the IPR system is to clean out some of these obviously invalid patents by using a post-grant review system that's cheaper, faster, potentially more accurate than federal litigation, why would we not want this class of defendants to be able to avail themselves of this process? The other side is, it's sort of weird, right? Sort of weird to have an agency petitioning another agency for relief from a private party's patent rights. And, as many of the justices noted, it would be even weirder if there was an appeal from an IPR ruling. And so that what would end up happening is agency versus agency in a federal court fighting over a private piece of property, right? So that's where the courts, the justices' heads were sort of exploding during this argument, you know, stringing out all of these hypotheticals. It's interesting to know, I don't have any good prediction as to how this is going to happen and come down. Only about 20 petitions have been filed since 2013 when the IPR system started, so it is not a big deal. So one answer might be that the court just says, well, Congress didn't clearly intend the government agencies to be allowed to do this, so since they don't really do it very often, we're just going to let it be and not allow them, because that would avoid sort of these what the justices clearly thought was a weird situation to have agency versus agency in the federal courts.
So, Paul, one additional thought. For the textualists in the room, there's a famous act called the Dictionary Act, 1 U.S.C. 1. It specifies that person, the words person and whoever include corporations, companies, associations, firms, partnership societies, and joint stock companies, as well as individuals.
Yes, which is exactly what the Postal Service argued. Justice Kavanaugh, in particular, was completely disinterested and argued that may, in fact, not apply in this case. So.
But the government's not there, so the question is, the textualists, what are they going to do with it?
Right, exactly. So we'll see. It's an interesting case. Has relatively little to do with patent law. Much more to do with what you think about sort of the structure of the federal government. Right? HP versus Burkheimer is a case that is sort of hanging out there. It's a petition for cert that the Solicitor General was asked by the court to file views on in January, and as far as I can tell, the SG has not actually done that yet. I don't know what's going on at the SG's office, because there's one that I'm going to talk about in a minute where they were asked to file in September, and they still haven't done it. So the question here is basically a Section 101 question, which is the Section 101 analysis entirely a question of law, or is it a mixed question of law and fact? The Federal Circuit held it was a mixed question. It was an overall conclusion of law with underlying factual components. That had at least part to do with the way that they came out in that case. And so the patentee here is arguing that it's a pure issue of law and that the Federal Circuit erred. It's pending. I don't think that the Supreme Court is likely to take this. Do they really want to get back into Section 101 yet again for the fifth time in 6 years? I think they may be much more interested in just leaving it alone at this point. But we'll see. It is hanging out there. It was on the conference in early January, or on the conference schedule in early January, and nothing has happened since then. RPX versus Chanbon is sort of an interesting case. Again, not so much about patents as it is about federal standing and jurisdiction. So RPX, as those of you who do patent law may know, is an interesting entity which basically they're providing a version of patent insurance, almost a reverse patent troll. Some people say they're really no different than a regular patent troll. They just sue people who own patents rather than people who do products. So in any event, RPX is a company that will, for a fee, you can sort of join their program. They will assert their own portfolios of patents. They will defend you against patent infringement. And in this case, what they'll do is they'll find a patent that might be of relevance to some of their customers, and they will file an IPR about it. And try and get it invalidated. So RPX files an IPR against Chanbon. Note that RPX is not infringing and will never be infringing. Everybody agrees. There's no infringement issue here at all. And so the IPR ends up that well, actually a lot of the claims, almost all the claims were ultimately upheld, so RPX wants to appeal, as the statute seems to indicate they should. But then they appeal to the Federal Circuit, and the Federal Circuit dismisses the case for lack of case or controversy, arguing that because there's no way that RPX could ever be liable for patent infringement in this case, they lack Article 3 standing to bring the appeal. And so the question is, does the American Invents Act actually grant RPX standing? And again, this appears to be something of a drafting error, where it's not clear what the statutory language is actually going to happen. The SG was asked to file views the 1st of October. That's a typo, 10/1/18. I don't think this seems like a likely grant, but who knows? Might be happening. So I want to talk now about two other things that I think are some of the most significant things that have happened in the patent system in the last at least certainly 5 to 10 years or so. So in October, the PTO issued a rule requiring the Patent Trial and Appeal Board, the board that does the IPR system and other post-grant review systems, to use what we know as the Phillips approach to claim construction, basically the same claim construction approach that courts do, as opposed to what the Patent Office does during the examination, which is use their own version of claim construction, which they call the broadest reasonable interpretation, right? You may ask why there are two different ways of doing claim construction out there. That's a great question, and it doesn't make much sense. The basic reasoning that the PTO gives is that they want their examiners to have as broad a net as possible for prior art. What this, of course, means is that examiners and courts are interpreting patents differently, right? Now, initially, the Patent Trial and Appeals Board, as part of the PTO, was using the PTO-approved approach, which was broadest reasonable interpretation. This led to a lot of consternation because that meant that this post-grant review system, which is quasi-litigation, it has a lot of the attributes of litigation, and it can remove rights that have already been granted, is using a interpretive methodology that is not the same one as you would get if you were doing traditional patent litigation, which seemed strange. So the Patent Office has done this and said we're going to use the same, we're going to follow the court's lead on claim construction. I think this is a good step forward. It increases the predictability and harmonization between the PTAB and the courts. And over time, and even more importantly, and I'll finish with this in a minute, that this is going to grow the importance of these decisions because there's going to be this huge new body, hundreds of cases a year, claim construction analyses independent of the Federal Circuit, which I think is an important counterweight to what's going on. Second, the Patent Office, not content to just do claim construction, has issued guidance on patentable subject matter. And in January, they issued guidance on the appropriate way to interpret Section 101 after Alice versus CLS Bank. The rule was final in early March. So this is, the Patent Office is using this literally today. The guidance states that claims directed to a practical application of an otherwise unpatentable idea are patentable, right? Anyone who's studied Alice or the opinions after Alice knows that this is, shall we say, a departure from what the Supreme Court said. The director of the PTO is not shy about noting this departure. In fact, he gave a speech last week where he suggested that they were, quote, overruling the Supreme Court. Not sure that was a wise thing to say, but it is essentially overruling the main import of Alice. Alice is pretty clear that it doesn't matter whether you have a practical application for your idea or not. If it falls into one of these categories of excluded subject matter, it is invalid under Section 101. This is extremely aggressive policymaking by the PTO. Just on Monday, the Federal Circuit refused to give it any deference at all, arguing that it was completely inconsistent with court opinions. So we're going to have a fun couple years of administrative law challenges around this rule, whether Skidmore deference applies, whether Chevron deference applies. It's going to be a lot of fun and full employment for patent admin lawyers too. And so this is just one of a long process. So I think a couple of things to look ahead, and one of the things that I've been thinking a lot about and working on a paper about right now is that the PTO has really emerged just over the last 18 months or so as the focal point and the real power in the patent system. Some of these trends are long-term. Starting in about 2015, the Patent Office finally got all its money. Until then, it was being looted every year for the general fund for the US. Now it keeps all of its money, so that means as it sets its fees, it can use that money to invest in technology, more examiners, more training, and so forth, and they indeed have done that because it's a cash flow positive operation. The American Invents Act with the new Patent Trial and Appeals Board and the post-grant review really sets up the PTO as a much more active participant in the patent system. It's now no longer just an agency that grants a patent and it's done and you never see it again. They are involved through the entire lifetime of patents now. And then we're now seeing with this new director a real interest in doing policy and in really sort of pushing the boundaries of what we think of the PTO being able to do in terms of changing the law. And I think this is really shifting the power of where we think about patent law works, away from the Federal Circuit towards the PTO, and I think that has long-term implications. Mostly good, I think, but also could be bad going forward. But I think that's something to watch over the next 12 months or so. So that is my talk about patents. Who's up? Cindy?
No,
No, you're. Birds up.
You sit there standing.
I think I'll sit. Okay, I don't have any slides. I do have a visual aid somewhere in my pocket. Find it.
Old school.
Yeah, this is old school. This is a 9-volt smoke alarm battery whose relevance will.
Hopefully not from your smoke alarm at home.
I'm going to talk about the Democrats and their antitrust tech proposals, and start out with a caveat. 3 times in political history in the U.S., antitrust has been a major statement in the Democrat platform and was intended to become a campaign issue. The first one was in 1912. There was a 3-way election between the Democrats, the Republicans, and Teddy Roosevelt's Progressive or Bull Moose Party, and all 3 platforms had major antitrust planks. Wilson won, and the result was a very, very powerful wave of antitrust legislation, namely the Federal Trade Commission Act in 1914 and the Clayton Act of the same year. The second time was 3 years ago in the Clinton-Trump campaign, where the Democrats had a very big antitrust plank. There was a whole lot of talk about it prior to the nomination. And then after the nominations and during the election, it just kind of fizzled. In fact, I can't hardly recall Trump and Clinton talking much about antitrust policy during the run-up, even though it was in the Democratic platform. Now this time, we have the third time in history where antitrust is on the front burner again as part of the campaign rhetoric of the Democratic Party. A lot of it, although not all of it, is aimed towards big tech companies, most particularly Amazon, Facebook, Google, and Microsoft. And I don't have any idea what's going to happen after things move along. I think the fact is it's kind of hard. The public has a short attention span for wonky things, as we know, and whether antitrust gets some staying power in the presidential debates is hard to say. But two big sets of proposals. I'll go through them rather briefly. First of all, the Elizabeth Warren campaign has made antitrust a big deal. In particular, a set of proposals directed at tech platforms. These are two-sided markets that mediate between different groups of buyers and sellers. They're purely digital, they're very large. The biggest offenders, which her platform mentions, are Facebook, Amazon, and Google. And for them, she has two main proposals. Let me just back up a little bit and say something about the problem she's addressing, which is monopoly. Okay, now, monopoly is a funny word in antitrust. To an economist, it generally means high price cost margins and output lower than the competitive level. For a lot of lay people, it just means somebody who's really big. And I think it's fair to say that the Warren proposals are directed mainly at big companies. They're certainly not directed at high consumer margins. Because frankly, we do have a problem, a monopoly problem in the United States today. Price cost margins have been rising since around 1980. They're as high as they've ever been. And the result is that output is lower, profits are higher. And so, we could do some real work in terms of increasing output. That would also create more jobs for labor, benefit consumers. But the particular companies that Elizabeth Warren is targeting are not the companies that are producing high margins. High margins usually come from manufactured products. Amazon Basics competitors, Duracell, which is owned by Berkshire Hathaway, Rayovac, Eveready, these are other manufacturers of batteries, fairly large firms, not as big as Amazon, but they're large firms with high margins. So for some reason, the Elizabeth Warren campaign is targeting companies that sell at very low prices in relation to marginal cost, whose output is very high. To the extent they injure people, the people they injure are mainly smaller competitors, although when you start looking at survey literature, that gets to be a pretty complicated story. Overall, customers love Amazon. When you start asking competitors, some of them dislike Amazon very strongly, but Amazon also acts as a broker to lots of small businesses. It represents them. It has basically two avenues for selling products on Amazon. Under one of them, Amazon takes care of pretty much everything. You can drop off your inventory at an Amazon warehouse. They will market it on their website. They'll take care of shipping, billing, and the whole works, take their commission out and pay you at the end. The other one involves more individual business person involvement. But overall, those people are pretty well satisfied with with Amazon. The real problem is that Amazon and Facebook and Google too, I'm not going to talk about them quite as much. The real problem is that Amazon is a very, very big firm. And then the question is it appropriate to go after a big firm like that under the antitrust laws? Well, Elizabeth Warren has two proposals. One of them is what she describes as the separation of platforms from commerce. She thinks these platforms ought to be regulated a little bit more like public utilities are regulated. And what she proposes is that very large platforms, and these three companies all fit into that classification, very large platforms that sell tremendous volumes of the goods of third parties be forbidden from selling their own goods. And the thinking is that it's unfair for Amazon to interpose its own business in competition with these smaller firms. And that's where my little Amazon Basics battery comes in. The manufacturers of batteries, these are household batteries in the United States, are relatively large companies. Duracell is owned by Berkshire Hathaway. Eveready and Rayovac are owned by a large holding company that is probably the biggest household battery manufacturer in the United States. They sell at incredibly high margins, many times as much as 100% over cost. And Amazon did with the batteries what it has done several times with various products, and that is it came up with its own name brand. This is Amazon Basics. Batteries are out of patent, so it does not need a license to manufacture them. There's no trademark infringement because it has its own trademark. And it sells that battery at a price that ranges from something on the order of 80% of the branded prices down to as little as half, particularly when you take a larger volume. So the impact of the Warren proposal is going to be that Amazon will no longer be able to sell Amazon Basics on its website. It will have to move them to some different distribution network, maybe another website that would specialize only in Amazon's own products, but you would not be able to put the two together. Now, I think that's a horrible idea. Number one, the presence of Amazon Basics on the Amazon website serves to force the branded battery manufacturers to lower their prices in order to meet Amazon's prices. So we're seeing closer competition. The people we're protecting here, Berkshire Hathaway, that's not the kind of small business somebody like Elizabeth Warren would want to protect. But that would in fact be what would happen. The branded battery manufacturers would take over all the battery sales on Amazon and relegate Amazon Basics to some secondary website. Consumers would undoubtedly end up paying more money because Amazon acts as a maverick, that is a firm that has lower costs and lower prices than its competitors, and so it's constantly forcing its competitor prices lower. And of course, as margins go up, the market for labor declines. That is, high prices not only reduce consumer choices, they also reduce the opportunities for labor because at higher prices, less is produced, and that produces less labor. I'm frankly mystified because Elizabeth Warren has made her career speaking up in behalf of consumers through various ways: bankruptcy law, credit law, unfair competition, and the like. And this seems to be directly opposite to what her career stands for. Now, the second proposal in Elizabeth Warren's platform makes a little bit more sense, and that is she would like more aggressive merger policy with respect to dominant platforms and tech startups. She mentions two in the platform. One is Facebook's acquisition of WhatsApp. The other one is not a tech acquisition at all. It's actually Amazon's acquisition of Whole Foods. And frankly, she's put her finger here on a fairly serious problem, which is that the big techs buy up small startups, typically in technical fields, although as Whole Foods suggests, not always, buys them usually when they're quite young, frequently buys them at very large price premiums, and the story about them is pretty complicated. Some of them are complements, and we generally think mergers of complements are beneficial. That is to say, if an acquisition of a small company can add something to a larger platform's products or services, reduce their costs or something like that, those are things we would like to benefit. In other situations, however, it becomes pretty clear that the effect of the acquisition of a small startup is to eliminate the potential competition of that startup. After all, Amazon, Google, and Facebook were all small startups themselves once upon a time. They know that, and they know that the next kid on the block is going to be a small startup, and what better way to knock off the potential competition of such a startup than to buy it. So the difficulty from an enforcement perspective, however, is how you distinguish the sheep from the goats. This is done at a very early stage. Warren's proposal is way too draconian. She would simply prevent all acquisitions that rise above a certain dollar level, which means that both socially or economically beneficial mergers would be condemned, as well as those that are socially harmful. There have been some solutions proposed to this problem. They are imperfect. Probably the one today that has the most traction is one that would permit the platform to acquire non-exclusive licenses to the technology of the acquired firm, rather than simply buying its assets outright. So, for example, if you're buying a small startup which has some patents or some copyrighted code, you could buy a non-exclusive license to that code. That would give the acquiring company everything it needs to duplicate whatever feature that acquired company has that it wants to have. What it would not give it is the right to file infringement suits against people who, other people who want to do the same thing. Of course, that's always one advantage of non-exclusive licenses. It gives people the right to do something without giving them the exclusionary right, which is what antitrust is concerned about. Frankly, the problem with the non-exclusionary right solution is that these acquired companies are worth a lot less money if the only thing a company like Amazon or Facebook can buy is a non-exclusive right, and as a result, that kind of reduces the value of the small firm and may reduce the inducement of companies to enter into those businesses. This is an area in which we've still got a lot of work to do, but in my view, the Elizabeth Warren proposal is way too draconian. Now, Amy Klobuchar also has, how am I doing on time?
You're doing fine.
Okay. Amy Klobuchar also has an antitrust proposal, a fairly substantial one, that applies only to mergers. It does not identify tech as such, but it clearly has been drafted with big tech mergers in mind. And that proposal is a little more wonky. It's more targeted at judges, antitrust lawyers and professors and so on, and a little less at the public. Rhetorically, the Elizabeth Warren proposal is, I think, powerful. Totally wrong-headed, but powerful. The Klobuchar proposal changes some words in the merger statute, Section 7 of the Clayton Act. For example, the current language of Section 7 prohibits mergers that may substantially lessen competition, and the new proposal would condemn mergers that may materially lessen competition. There seems to be a lot of uncertainty about exactly what the difference between substantially and materially is, although there does seem to be a consensus that materially is a lower standard, so to yield a more aggressive policy. The other thing the Klobuchar proposal does is identifies the harms in mergers with heightened concentration, although problematically without paying very much attention to how much concentration there is in a market to begin with. When we say market's highly concentrated, that means it has a relatively small number of firms. The language appears to condemn mergers at much lower concentration levels than we are currently doing. Now, I think that's a step in the right direction. The question is how far you want to go with it. Today, we don't condemn mergers usually unless there's as few as 4 or 5 firms in a market. By contrast, if you look at the Warren Court back in the 60s, we condemned a lot of mergers in which there were 50 firms in a market, and the market shares of the merging firms were as low as 4 or 5%, and there wasn't any model you could come up with that would predict any price increases in those firms. And frankly, if you look at the Klobuchar proposal, it would also condemn mergers where it would be very difficult to identify which mergers would be likely to cause price increases and which we would not. So my real problem with the Klobuchar proposal right now is lack of a theory other than simple bigness. It's one thing the Warren proposal and the Klobuchar proposal have in common, but lack of a theory other than simple bigness about who is being harmed by anti-competitive mergers. Current theory says it's consumers concerned about mergers when they raise consumer prices, and then what kinds of tools do we need to predict? Remember, we try to analyze mergers before they occur, and the statutory structure permits us to do that. That's a good thing, because unwinding a merger is very costly and upsetting to the economy. On the other hand, predicting the effects of a merger before it occurs is very difficult. So I'm somewhat more sympathetic with the Klobuchar proposal, but I think it needs a lot more vetting before it goes anywhere. Unfortunately, I don't think the Klobuchar proposal is going to ever show up on a televised presidential debate. There's just not anything in it that a general audience is going to be able to relate to.
So it's interesting in terms of framing this. We live in very interesting times. You know, traditionally, the support for rigorous antitrust has come from the Democratic Party and progressive left. In the current environment, it's being embraced by the far right, the Steve Bannon far right as well. And it's creating a very different political dynamic. It is also being fed by some rhetoric from President Trump and not liking big companies, and particularly accusations that he's using some of these prosecutions for political motivations, particularly his case against the AT&T Time Warner merger, because he does not like CNN, which is part of Time Warner. And so we have this very complicated world. We have international enforcement agencies, Japan, Australia, the EU, the UK, moving in the directions that Herb is kind of talking about. And what we see is normally a Republican administration that would be reliably in favor of traditional antitrust is holding a series of hearings, which many of us observe is much more interventionist. And if you want to know everything you know about the quality of these hearings, they've invited me to testify twice and have not invited Herb at all. And that tells you that's not right.
I think that's right.
But more importantly, the FTC recently appointed a high-tech task force with the affirmative goal of examining whether they should unwind some past mergers. And for the reasons Professor Hellenkamp said, that's an extremely unusual thing for any administration to do, let alone particularly for a Republican administration. So it's a bit of a huge surprise. The saving grace, and this is an interesting case where Professor Hellenkamp and I were on opposite sides of briefs signed on this, is the AT&T Time Warner merger. I don't know how you feel about the outcome, but the one thing I will say, it went by economics, numbers, traditional analysis, and effects. And maybe people, it didn't show any signs of just upsetting the whole apple cart and doing something very differently. Now, people may think that the evidence was misread wrong or anything, but I think it does not show the signs of radical change. The only thing that's real, the one other sign of radical change, tying to the other thing you were talking about, which is For these startups, their clear ambition now is no longer IPO. Their ambition is to be bought by a large company. And that is an interesting, when you talk about limiting their markets by these, this is their going-in strategy more often than not, with a handful of exceptions. And that's a really interesting change in the Silicon Valley mindset. It could be it's the aftermath of the overexuberance of 20 years ago in '99, and where venture capital threw funny money around and it was ridiculous. But it is pretty clearly, from the startup standpoint, a bad thing to limit their exit markets, in much the way you described.
Yeah, that's true. And clearly, a limitation of non-exclusive licenses will have an effect on acquisition prices, although the extent of the effect depends greatly on the nature of the acquisition. If it's the acquisition of a competitor, so that it threatens to produce collusion, then making it a non-exclusive license very largely makes it worthless to the acquiring firm. That is to say, there's no point in acquiring a competitor in order to shut it down if the only thing you can get is a non-exclusive license, which means that the competitor itself will stay in business. On the other hand, if it's a complement, if there's some feature that, for example, Facebook wants to add to its current product and service model, and this acquired startup offers that, a non-exclusive license may give Facebook all it needs. That is to say, all it needs to do its own business is to have the non-exclusive license, and it may not care nearly as much whether it's able to shut down the rival.
Well, thank you very much, Professor Dahl.
Okay, so I'm going to turn the discussion in a trademark direction. And I'm going to discuss two cases that are before the Supreme Court. I'm going to save the salacious and more, famous case for second, but I don't want to give short shrift to the first case because I've been told that this is the most important bankruptcy case of the year, and INTA, the International Trademark Organization, says that Mission Product Holdings is going to solve a problem that has existed in trademark law for 30 years. So we should definitely give some time to Mission Product Holdings, even though it is actually really a bankruptcy case with trademark overtones. Okay, so the first case, a little bit of background for people for whom bankruptcy is a distant past. In bankruptcy, a bankrupt debtor licensor has a choice. They can either reject or assume the prior licenses and other executory contracts, but it's their choice what they want to do with their prior licenses. So this presented a problem in 1985 when a debtor licensor decided to reject a license, and they were allowed to void the entire contract, which basically pulled back all of the rights that they had granted previously to the licensee. This was a Fourth Circuit case 30 years ago. So as a result of this bad result for the licensee and the uncertainty that it would inject into licenses, into the licensing system, Congress actually amended the bankruptcy code in this section that is at the heart of this case called 361N. And this change allows licensees to elect to retain those rights that they got under the prior license, even if that bankrupt licensor has rejected the license. So their rights are protected. The problem was that Congress specifically talked about patent, copyright licenses, also trade secret licenses, but they specifically left out, or maybe didn't specifically leave out, they did leave out trademark licenses. So for 30 years, there's been uncertainty in this area, and thus this case. Further complicating facts, a couple of years ago in 2012, there was another case that talked about this exact issue called Sunbeam Products. And in Sunbeam, in the Seventh Circuit, they said that the debtor licensor can reject the license and terminate all of its obligations, and the licensee can sue that licensor for breach, but the rejection does not terminate licensee's rights. So it basically put into motion Congress's change. But now we've set up a big circuit split between First Circuit and Seventh Circuit. So what happened in this particular case that brings it to the Supreme Court's attention? So this is a case over athletic exercise wear and a cooling technology for exercise clothes. And Mission Product Holdings had a license from Tempnology Products, and then Tempnology, it included Tempnology's trademark name and logo, and then Tempnology filed for Chapter 11 bankruptcy. It promptly rejected the license. And the bankruptcy court sort of went back to what the case was 30 years ago, where they said that Mission Products' only remedy was to sue Tempnology for breach and basically get in line as a creditor and try to get damages that way. Tempnology no longer had to perform its obligations under the license, and they classified one of those obligations as the obligation to continue to license their trademark rights to core Mission Products. So Mission Products basically was out of luck. They appealed to the First Circuit, which affirmed the bankruptcy court, and now we have it before the Supreme Court. So here's the question presented, and basically it boils down to, are we going to treat contracts differently under the bankruptcy code than we are under just sort of general contract law? So does Section 365 say that when a debtor licensor rejects the license, and it does constitute a breach, because later on in that statute it says that rejecting equals breach, does it terminate all of those rights that have been granted to the licensee that otherwise would survive any sort of breach under contract law? So is bankruptcy law magically different because of 365N or not? Okay, so the arguments have been heard in February. There's no ruling yet. But we have some indications based on what the arguments were and the justices' reactions to the arguments that they're fairly sympathetic to the licensee. So just to sort of summarize, Sotomayor originally started out sort of pro-licensor and said, well, Congress only spoke to patent and copyright licenses, so they must have meant to leave out the trademark licenses. Ginsburg says, well, that doesn't actually follow. Just because Congress didn't mention trademark just means they didn't mention trademark. So they didn't rule one way or the other on trademark, so we can go and interpret however we'd like. And then the more convincing petitioner's argument, picked up by Kagan and Breyer and Alito, said, hey, let's look at general contract law here. And generally, rejecting a license is a form of breach. And in all other contexts outside of bankruptcy, the breaching party can't just pull those rights back. So what happens is the licensee keeps the rights and then just sues for any breach, any damages that come out of breach. So reading the tea leaves, it looks like more justices are on the side of the licensees. We'll see what happens when they issue their opinion. There is a little wrinkle about whether or not this could be declared a moot topic to rule on, and if that happens, of course, we'll get no clarification, but hopefully this case will put an end to a debate that's existed for 30 years and help the attorneys of trademark owners and people who are licensing to get some certainty in this area of the law. A couple of interesting questions actually out of this. Besides, I'm going to take the second one first. Besides the fact that this really sort of sets up a tension between what happens in bankruptcy and what might happen in regular contract law, basically that when the contract is rejected, the only right of the non-breaching party is to sue for breach as a creditor. That's what the licensor is saying in this case. Should that override this long-standing view that under contract law, breach doesn't extinguish any rights? So that's kind of an interesting dichotomy, and I think we're going to get some certainty out of this. I read that it really turns on whether granting the rights is seen as a transfer of property or merely just a contractual obligation of the licensor. How do you view that, that license, the transfer of the license rights? If it's a property right, then you shouldn't be able to, the licensor shouldn't be able to get it back. But if it really is just based in a contractual obligation, then perhaps the breach should be able to rescind the rights. So that's one sort of interesting question. The second interesting question, I think is even more interesting, is the first one I have on the top of the slide. So if you're basically saying that a rejection does not pull back rights, what does that mean for enforcement of that use of the trademark? If you're a trademark lawyer, you understand what a naked license is. Basically, this means that because a trademark identifies a source, you have to control what any party to whom you license your trademark does with your trademark. And if you basically have rejected the license, so you're not going to enforce anything anymore, but yet the license rights are still out there, have you entered really into a naked license? And what does this do to your ownership of the trademark? Because trademark law says if you license under a naked license, then basically your rights could be extinguished. So are we forcing people who are in bankruptcy to choose between whether or not they want to reject the license or whether they're, whether they want to reject the license and probably not anymore exercise that necessary control over the license, or to lose the mark? So I think that's sort of an interesting question that's sort of underneath this case. Then the case that most people are talking about in trademark world now, Ianco v. Brunetti. So this case, at the heart of this case is Section 2A of the Lanham Act, which talks about certain categories of marks that may not be registered or granted registration by the USPTO. And one remaining area of mark that is not supposed to be granted registration by the USPTO are marks that are immoral or scandalous. So who's behind this case? This is a picture of Eric Brunetti. He's quite a colorful character. He describes himself as an artist, designer, and founder of the, forgive me, we're just going to do blanket forgiveness here, of the fucked lifestyle and clothing brand of streetwear. It's actually been around since 1990, and he says that that word actually stands for friends you can't trust, but I think the USPTO completely saw through that, of course. The brand has a lot, or had a lot, of punk cred, apparently. He actually, besides this edgy name, he's done a lot with the brand to sort of stick it to the man. It generally challenges accepted social mores. If you see what he's done with appropriating other people's marks and other ideas, he's trying to be very counterculture. So this is the guy behind this case. He's filed for federal registration several times, but the time that is at issue here is when he filed in 2011. Of course, the examiner denied the registration, deeming it immoral or scandalous and vulgar, totally vulgar, because he said the fucked mark was actually just masquerading as the past tense of the verb. The TTAB upheld the examiner's decision on appeal and said, yeah, you're absolutely right, this is vulgar. So, but interestingly, meanwhile, at the Supreme Court, they were considering a different case called Mittal v. Tam. And what was happening in Mittal v. Tam, it was over a band called the Slants. They were an Asian American band that said that they wanted to actually appropriate what they thought was a derogatory term for Asian Americans. They wanted to actually take it back and reclaim that racial slur. So they had a reason why they wanted to call their band what some people may have thought a derogatory term, and they wanted to trademark that name. The USPTO denied that registration on a different part of 2A, that you could not register marks that may disparage. Both TTAB and then the Federal Circuit affirmed the decision of the USPTO on disparagement grounds, and then the case came before the Supreme Court in 2017. In 2017, the Supreme Court looked at the disparagement clause, part of 2A, and struck it down as unconstitutional under the First Amendment on using several arguments. First, they said, unlike what the USPTO argued, trademarks are private speech. They didn't agree with the USPTO saying that they were potentially a government subsidy or government speech. They said no, trademarks are private speech. And even if you consider them commercial speech, they said that the restriction did not serve a substantial interest and was not narrowly drawn, so therefore had to be discounted under the First Amendment. Remarkably, the Supreme Court did not rule on the second part of 2A, that other part of that element, the immoral and scandalous restrictions, so that's why we have Brunetti. So Brunetti appealed his TTAB refusal to the Federal Circuit, and because of Mittal v. Tam, the Federal Circuit asked Brunetti for some additional briefing. And then in December of 2017, the Federal Circuit panel issued their unanimous ruling that the USPTO's restriction on granting registrations for immoral and scandalous marks was unconstitutional. Likewise, they called trademarks expressive speech, and as expressive speech, they said it doesn't survive the regulation can't survive strict scrutiny under the First Amendment. Then they said even if it's commercial speech, it doesn't survive intermediate scrutiny, and most importantly, they say that the regulation was impermissible discrimination on the basis of content. So the Supreme Court granted cert January of 2019, and Brunetti actually, true to form, didn't actually counter the question, he added a new question. So there are two questions that are presented. It's not clear whether the Supreme Court granted cert on one or both of the questions, but these are the two that are out there. The one at the top, mirroring Mittal v. Tam, whether or not the prohibition on federal registration of immoral or scandalous marks should be facially invalid under the free speech clause of the First Amendment. And then Brunetti also tosses in a second question that it is unconstitutionally vague under the First and the Fifth Amendments. Okay, so what has been said? I'm sorry, in the briefing, I should say that actually this will be heard before the Supreme Court in 2 weeks, April 15th. So it should be an interesting case to see what comes out of it. But so far in the briefing, the petitioner says that this is a completely different case than Mittal v. Tam. That Section 2A, actually the restrictions of the USPTO under Section 2A, they're not prohibiting speech or restricting trademark use because, of course, you can have common law use of trademarks. They're saying that it just prevents the government from putting an affirmative stamp on vulgar terms by granting the benefits of registration. They also said that just because it sets forth eligibility requirements for that federal trademark registration, it is viewpoint neutral. We can talk about whether you think that that holds any water at all, but that's what they're saying. And then they're saying that trademarks might not be that expressive speech anyway, sort of revisiting prior arguments, that it's more accurately a lower level of speech that could be subject to more regulation restriction. And then they just throw a kitchen sink in there too. There are legitimate justifications for the clause in any case, so figure out what that is. Okay. So the arguments are set, as I said, for April 15th. Hopefully we'll have an answer before July. We just held a panel on this case a couple of weeks ago, and one of the questions that was handled by the panel was, why would the Supreme Court take this case up? I don't know, maybe back to Polk's comment, maybe they needed the work, I'm not sure. But you would think that under Mittal v. Tam that we would have kind of put this to rest, and we're seeing a lot of the same arguments again. But apparently the Supreme Court has more to say on this issue, and they were not unanimous in their reasons for overturning the restriction on the basis of the First Amendment in Mittal v. Tam, so maybe we'll have some more unity in this decision. We also have two new justices on the Supreme Court now than we did in Mittal v. Tam, so that may change what the result is. Most people are thinking that that this will be held unconstitutional under the First Amendment, this new element of 2A, but we'll have to wait to see.
And if I remember correctly, one of the odder things about this case is the actual registration of the word was not an issue. That's been registered years ago. He just put it with a new logo, and they denied registration of the new logo. So technically the word is still registered regardless of the outcome of this. But it's clearly being litigated as if the word is an issue, so it's fast.
And there are so many words at this point that are registered that may be considered vulgar, immoral, scandalous. It's just interesting that this is where they come from.
Anyway, thank you very much, Mr. Dole. Mr. Walker.
Okay, so moving from trademark to copyright, I think we have a very similar theme here. There's no clear answer for why the Supreme Court takes the cases that it does. This could not be more true in the copyright space, where it took and decided to what can only be described as completely inside baseball procedural questions. But if one had to really look for a common theme in them, I mean, when I say inside baseball, these are not even questions that one would confront in an introductory copyright class. These are the questions that you have to be a copyright filing lawyer to really confront. But one common theme in both these cases, I think I want to pick up on where Professor Dahl left off, is they're really questions that turn on the structure of the statute. And I wonder whether one of the themes that we're going to see in the Supreme Court's copyright jurisprudence, maybe even beyond that going forward, is the level of the court's engagement with the statute, right? The extent to which the court is trying to reinforce the idea that the text of the statute ought to dominate the conversation about copyright principles. So what were these two cases? The first of these is Fourth Estate versus WallStreet.com, and both the cases that were decided by the court were decided unanimously, 9-0. Again, not very, very common in the copyright space, because leaving all other politics aside, Breyer and Ginsburg often, if not always, do not see eye to eye on most issues involving copyright policy. But these are both 9-0 decisions. And the Fourth Estate case really revolved around one question, which is a section 411A of the copyright statute, Title 17. And copyright protection is a basic principle we know. Copyright protection begins from the moment the work is created and fixed in a tangible medium of expression. However, a cardinal rule of the US copyright system that has predated the 1976 Copyright Act is that in order to bring an action for copyright infringement, you needed to get a copyright registration. This is something that existed even under the regime prior to the 1976 Act. Section 411A makes that explicit and provides that no infringement action may be commenced until a registration has been made. The actual terminology is registration of the copyright claim has been made. The circuit split that the court was confronting was the fact that one set of courts had interpreted this, one would say in a plain, reasonable, and obvious manner, to say registration means an actual registration. 411B and subsequent subsections talk about what happens if the register actually denies you registration, so you can actually go ahead and file after a denial, which means that 411A on its face seems to suggest that registration means a registration, that a decision had to have been made on the registration itself, either a grant or a refusal. But another set of courts had adopted a more pragmatic position, recognizing that from the 1950s, when the registration process took less than a week, sometimes 2 weeks, to now it's about 6 to 7 months, to avoid keeping the copyright plaintiff hanging, the plaintiff could bring an action when the application was pending. This was called the application approach. The prior one was called the registration approach. And the question was, which is the right reading of the statute? And the court answers this in an opinion authored by Justice Ginsburg, that no, actual registration means registration. The court says, look at Congress saying the word registration. We don't know how to make sense of the application approach if we have 411B, which talks about the fact that if there's a denial of registration, you can do something else. There's no discussion of an application for registration and what you can do in that situation. In fact, there's even talk about you can make the government a party in an actual denial of registration, which is the accepted protocol. And for certain kinds of works where you need an expedited registration, there's something called pre-registration. So putting the text and context together, Justice Ginsburg says, a very, very straightforward and obvious answer, registration means registration. We needed the Supreme Court to tell us that, 9-0. Right? Now, what's the effect of this ruling going to be? I think it's going to be largely moderate, in the sense that in the circuits where the application approach was being adopted, you're going to see litigants actually doing what the copyright statute intended all along, which is go to the Copyright Office, game out how long that's going to take, so figure out the time between the creation of the work, how valuable it is, what the time span is going to be for commercialization, and very importantly, what the likelihood of copying is going to be in the interim, and you start registering it up front. The main change that you're going to see, and the reason I did not say mild, I said moderate, is in some industries where there's a tendency for infringing copies to go viral, right, which is one of these things with the video game industry. I think you're going to start seeing actual registration numbers go up, which is what Congress intended all along. That with every iteration of the game during its development in the software industry as well, you're going to see much more registration. You're going to see, in other words, the software industry becoming closer to the protocols that Hollywood adopts. So in Hollywood, the established protocol is at the end of each day of filming a video shoot, those reels, the actual reels in and of themselves, in the unedited version, are registered with the Copyright Office at the end of the day. Why? Because you never know where something is going to be leaked and actually be stolen and infringed, and you want to ensure that you preserve all the remedies that Title 17 offers you, right? Statutory damages, attorney's fees, et cetera, and the reason you do, and so you have an iterative process of registration. I think you're going to start seeing that with other industries where the time lag between production and copying could be very, very minimal, such as the video game industry. But beyond that, I don't think it's going to cause too much of a difference, because I would have thought most people recognized that registration meant registration, and it was really a smaller category where you applied for something, it was pending, and I was talking to the head of the Copyright Office that actually works on the registration side, and I think they've really tried to streamline the registration process, where in recognition of what 411A and 411B actually do. So to actually have a loophole to what Congress had intended, and then to have them try and plug that loophole was just a little bit problematic. So I think this is the right decision, but again, not clear why the Supreme Court had to waste its time, because believe me, there are a lot of, in my view, more important Supreme Court precedent issues that they could have taken even on circuit splits. Sorry, circuit splits. The second one, decided also 9-0, even more inside baseball in some ways, has to do with a specific phrase in section 505 of the copyright statute, and this is the case of Remedy Street versus Oracle, thank you, which in section 505, the statute uses the phrase full costs when it allows the court the discretion to award full costs of the litigation for an actual prevailing party. However, there is a general statute which empowers federal courts to award costs, which specifies the categories under which the costs need to be classified before they can be awarded. This is in Title 28. This is sections 1821 and 1920. And so the question was whether, in a particular case, I think in this case Oracle won an award of about $12 million, which included literally all the costs of litigation that the court had granted, and without the classification demanded by Title 28. And the question was whether the copyright statute can override the requirement in Title 28. And in an opinion, again, entirely based on statutory interpretation, the court concludes no. The copyright statute has to be subject to general limits. There is no express override, which is what we would require as a matter of statutory interpretation if Congress had wanted the copyright statute to move away from the general category. And the court also points out that there's really no interpretive basis for the argument that full costs really means costs over and above and beyond what Title 28 encompassed. So again, a straightforward attempt to interpret the statute to suggest that congressional intent has to override any court's attempt to try and generate copyright policy in the copyright space. The impact is likely to be moderate because all along Section 505 always said discretionary, and there was no real pattern in the way in which this discretion was exercised, which has been a story with copyright remedies under Section 505 ever since Fogarty versus Fantasy. We have no idea how that discretion is meant to be exercised. So given that reality, I think the impact is likely to be moderate. In my view, the only interesting thing about this case was that Justice Alito initially recused himself because apparently his financial disclosures showed that he had anywhere between $15,000 and $50,000 of Oracle stock. And then he divested himself before oral argument. And so one recused himself and heard oral argument, and then we got a 9-0 decision. So I think that was the only interesting thing in this. Because Oracle is likely to come up before the court again in a case that I think is really cert-worthy. Right? The Supreme Court would be doing copyright jurisprudence, the copyright system, and the substantive law of copyright a real service if they took cert in this case. So Oracle versus Google is a case that involved Google's alleged infringement of Oracle's patents and Oracle's copyright registrations in its application program interfaces. Because it involved a potential infringement of Oracle's patents, the matter goes from the district court in California on appeal to the federal circuit. But by then, Oracle decides, and through a variety of different procedural motions, that the patent element is not really a big deal. And so court gets jurisdiction over copyright. The federal circuit gets jurisdiction over copyright entirely as a matter of supplementary jurisdiction. And we have two opinions handed down by the federal circuit, which, if I may say so, make a mess of copyright law. The first one on an interpretation of section 102B, which is one of those provisions that has a historical lineage in the copyright system dating back to the 19th century, and the first or second copyright case that every copyright student studies, Baker versus Selden, and its interpretation. And the court sort of tries to run roughshod on the way in which Congress had intended to put that into section 102B. But what is interesting more than anything else is the court doesn't pay attention to the unique jurisdictional position that it's occupying. Because remember, the case is coming from a district court in California. And each circuit, for all intents and purposes, in the copyright area, has its own interpretation of the copyright statute. So the federal circuit, however, doesn't really have a copyright jurisprudence of its own. It's applying local jurisdictional law, namely it's applying Ninth Circuit law. And it's suggesting that it is applying Ninth Circuit law in conformity with the Ninth Circuit's own interpretation of section 102B, which is not true. But the irony is there's no way for the Ninth Circuit to say no. Right? Because the Ninth Circuit can't sit and overrule what is a federal circuit decision. So in other words, the only way for the and Peter Minnell, professor at Berkeley, makes this argument very, very forcefully in a paper in the Berkeley Technology Law Journal. The only way that this issue is going to get resolved, which is the federal circuit misinterpreting Ninth Circuit law, and then not leaving the Ninth Circuit a way to correct it, is for the Supreme Court to jump in. So regardless of what your position is on the issues of substance in Oracle versus Google, even if you can see that it's a close case, in fact, probably the most important case on the question of software copyright and its applicability, or the applicability of section 102B to software copyright, you have to concede that this is an important case from a procedural and jurisdictional point of view, because the closeness of the case is never going to be resolved without the Supreme Court actually granting cert. So the current state of affairs is that Google has filed its cert petition. A whole bunch of amici have followed suit, and I will make a concession that I signed one of the amicus briefs trying to urge the court to take cert on this matter. Oracle's response brief is due in a few weeks, and then I suspect as they did in the first round, the court will invite the Solicitor General to weigh in. The first time, so remember there were two cases that went up to the federal circuit. The first time the cert petition happened and SG was asked to weigh in, SG said no, stay away from this case. We agreed with the federal circuit. Not clear what the SG is going to do this time. We have a new SG, of course, and so we'll see. My guess is that there's a good chance the court will take cert. Why? For two reasons. One, it's an important case. It's getting a lot of publicity, which at least in the copyright area, I think exerts some unknown pull on the court's willingness to grant cert. Case in point, Petrella versus MGM, a really, really narrow inside baseball case. The only reason why I think the court eventually took it is because the justices probably saw a raging bull at some point and said, oh, it's a really important case. People writing about the case will be able to connect it to the actual movie that it was based on. So Oracle v. Google has been in the news. So that's one reason. And I think the second reason is it will allow the textualist justices to connect to be able to relate the copyright principles to section 102B, to try and understand the interface between the text of the statute, because it is a closely worded and a hotly debated provision that eventually made its way into the actual text of the statute, how exactly that's to be interpreted in light of broader copyright principles. So to the extent that that is a common thread that one is seeing in the last few copyright cases, I suspect the court may be inclined to grant cert, but only time will tell. Hopefully we'll have some clarity at the end of it. That's copyright law.
Just briefly to add a few thoughts, the other area of law is privacy. We did hold an event on this 2 months ago, so I'll do this at some brevity because some of you might have been here, but there's been actually a huge sea change in privacy law, probably demonstrated most eloquently by the op-ed published by Mark Zuckerberg in the Washington Post earlier this week, basically embracing federal legislation. And the thing that's happened is we all thought we'd be talking about the new European regulation, which is called the General Data Protection Regulation, otherwise known as GDPR, which went into effect in May. As it turns out, that was not the meteor that was going to shake everything up. The meteor that's shaking everything up is a California privacy statute passed in August. The minute it passed, the California government, the legislature then held it in abeyance until January 2020 and agreed not to enforce it. So what is going on? It's a very odd piece of legislation. The history of it's odd. California has referenda. A person put a privacy referendum on the ballot. The weird thing about privacy, there's two problems about referenda. One is whoever has the pen can control the outcome by the way they frame the question. In a very famous case in California, there were two referenda that were actually mutually exclusive, and they both passed. Because the author was able to write it in a way that they made it sound like a really great idea. So this is what happens. So the person put a privacy referendum on the ballot. The other problem is if it's enacted by referendum, the only way to modify it or abolish it is by referendum. So the reality is once you do it that way, these laws are very hard to change. So the author of the referendum agreed that he would withdraw it if California would pass comprehensive privacy regulation. And by the way, you have to do it in a week because that's when the referendum's going to happen. So California passed comprehensive privacy legislation in a week. Needless to say, that's not the appropriate amount of time for doing major reform legislation, so that's why they immediately held it in abeyance. What it's done is it's changed the status quo. If nothing else happens, California goes into effect January 2020. And now Google and Facebook and the other companies that are opposing federal legislation now support it. It's not a question of if, the question is what it's going to say. And what you'll discover is they have much more agreement about there should be federal privacy legislation and the important things that preempt all state law. There's rampant disagreement on what it should actually say. And so we're going to have to wait and see. This is actually one of the few things I've seen that actually has a prayer of passing this Congress and be enacted in the law that will be subsequent reform. And the most interesting thing about the California privacy law is its primary focus is on third-party transfer of data. This has killed the data broker market in California, which means that the new companies that need to get access to data actually are the ones, the smaller enterprises are being harmed more. And in fact, Google and Facebook do not rely on the transfer of data from other people. They're likely to do just fine. So they're actually wanting just uniformity. It's created a really interesting set of dynamics that have been thought about in privacy law. The most significant things is, again, the change in stance of the companies, but the fact that Facebook is actually changing its business model in response to not just this, but the bad press it's been receiving all the way around, and the more we learn their practices are really quite bad. That they're moving away from the traditional Facebook communication system of putting public information on walls to interpersonal, person-to-person communications. And anytime you see a company of Facebook's magnitude changing its fundamental business model, this is one of the riskiest things a company can possibly do. And this is a major concession on their part that there's enormous problems going on within that company. And it really raises the question of what that company is going to be in a few years. Because if you make that kind of change, there's no guarantee your revenue will even remotely resemble what you had before. We are cursed or blessed to live in interesting times as far as privacy goes. There's a lot more I could say about that, but given that we have 10 minutes left, I wanted to make sure I reserved that time for any questions that anyone in the audience might have for any of the panels. Before we do that, I have one more caveat. I should have said this at the beginning. This is being video recorded. So there is a disclaimer you come in on the static view. By coming in the building, it's a standard disclaimer that people can, we will take static videos, but if you do ask a question, it will be recorded on video. So if you have concerns, please adjust your conduct accordingly. Andre.
Thank you. I have an interest in the trademark case involving bankruptcy, and I have to say that I'm not entirely sure that if the Supreme Court comes back and says, well, we should just rely on contract law and therefore allow the licensee to keep the rights of what are under the license, I don't think that really does it. And that is because the regime that has introduced via 365N goes beyond that. So for example, under 365N, the licensee also retains the right to extend the license if that was initially provided under the original contract. So if you have such an option, you can go ahead and extend. The other problem, and I'm not quite sure that if you reverse the basic contract law, it still applies in the same way. And then there are a variety of elements of 365N that, in my mind, go beyond basic contract law. But the other point that I have is that, to me, it still doesn't work out when you have trademark as the odd man out, because in so much that we see today in sort of how the business world works, intellectual property rights tend to be bundled together. So when you take out a license from someone, you're not, sometimes it'd be a discrete license for one IP right, so for a trademark or a patent or a copyright. But at least in my experience, ever more frequently, you're taking out licenses that cover more than one. And so this split in treatment between different intellectual property rights, licenses in bankruptcy, to me makes absolutely no sense. And even if the answer is, oh yes, let's revert to basic contract law, it's still not really addressing this particular problem. You have licenses for all other IP rights that follow one regime, and then trademarks that exist on a different plane. Maybe we are reducing the gap a little bit, but we're still keeping it there, and we're still not resolving all the problems that arise in bankruptcy.
So I'm not sure I completely understand the second question, which I want to address first, because if they do bring trademark under the same realm as patent and copyright, then we're addressing.
Well, okay, my point was that based on the oral arguments, the chances that, in my opinion, the chances the Supreme Court comes back and say, okay, let's read the definition of intellectual property broadly and include, I would love for them to do that. That to me would be the best outcome. They come back and they say, okay, yes, let's interpret that definition of IP broadly, let's include trademarks, let's extend 365N to them. That would be the ideal answer. My suspicion is that that's not going to happen because of the textualist approach that we've seen also in other areas, and we're going to say, if the definition doesn't have trademarks, then we just have to take that as a starting point. So I was simply assuming that's not going to happen and looking down the chain.
Don't know. We'll have to see what they do. But I think all other IP regimes are represented at this point in the definition. You've got trade secret as well as patent copyright, so they just need to bring trademark along. And interestingly, I think this is a good case for them to take because the Tempnology license it implicated different kinds of IP. And so even in this particular case, certain parts of the license continued and certain rights did not continue, which is kind of interesting. But back to your first point about whether it's fair because the licensee maintains the right to extend the license further, I think what they might say to that is that the licensee has all rights and obligations, and so they're going to have to, if they're going to extend that license, they're going to have to pay for that. And so that's how it sort of comes back to basic contract law.
Yeah.
But interesting points. I think there are a lot of nuances in this case that we'll have to see how they deal with it.
Please.
Question for Professor Wagner regarding patent office. So it seems that the patent office on one side mentioned that they're trying to reconcile the review standard by getting rid of ERI and having the same standard that the federal courts have. But on the other side, they're trying to now have this, saying that we won't rule the Supreme Court doesn't sound right, but they are being very aggressive, and you can argue that they're trying to be pro-patent here by taking the position that they have. So how do you see that this, it sounds like we're going to see a back and forth between Federal Circuit and Patent Office, as it already started this Monday, that the Federal Circuit said we don't care about what Patent Office says or what their guidance says. We're going to have our own rules based on what we think the law is. So how do you think that's going to play? And do you think that Supreme Court is going to come in and try to resolve it?
I think it may ultimately have to be resolved by the Supreme Court. What's interesting about the case that's on Monday is that this was, these guidelines are very new. So the particular patent involved there had not been evaluated under these guidelines, right? This was just something that the patentee picked up and literally brought it to oral argument and said, well, here we have a new interpretation of Section 101 you should follow. So you might understand why the Federal Circuit was probably pretty reluctant to sort of, it hadn't been briefed. It was just sort of off the cuff, and they said they weren't going to pay attention to it. It was an extremely short, about a half a paragraph analysis where they just rejected it, and they designated the opinion non-precedential, which means that they don't want anyone to cite them. So, which is disappointing, and shouldn't be allowed. But that's a whole different story. So we'll see. I think we will see a bit of a struggle or a dance. I mean, the interesting thing is that where the PTO has landed now is essentially where the Federal Circuit was pre-Alice, right? Pre-Mayo, pre-Alice. So, as long as they, wasn't quite in this this phrasing, but given, that they have to sort of layer this on top of the Alice and Mayo approach, they're pretty much to the point, maybe not all the way back to State Street, but somewhere close to there, where, as long as you're describing a tangible, practical, useful application of even an abstract idea, then it seems like the PTO wants to grant that patent.
Yeah, I mean, it sounds like there is going to be, like, we as a patent practitioner will have to live this hard life where, you'll think like, oh, I got my patent or
Yeah.
claim set, clear on 101, and then you say, like, patent Federal Circuit said, wait, no, you're not
Right.
clear. And here's why you're not.
Yeah,
I mean,
and
that's-
And the Patent Office guidance is very clear that they are also instructing the judges at the PTAB to use the new guidance as well. So, at post-grant review, you'll be getting the newer guidance. So it'll be just the courts where you might get a different guidance. But yes, it is, we are going to enter a period of uncertainty. Not that, Alice is a mess anyway, right? And the damage from Alice had been spreading into medical devices and all sorts of other areas of industry. So I think that, my sense is that the leadership at the PTO thought that this was sort of a crisis situation, that they had to try to do something. It was, the rejection rates for a lot of these technological areas, as you probably know, are just crazy high. On 101, where the examiner doesn't even have to point to any prior art or do any actual argumentation. They just sort of, cite Alice and move on. So.
We have time for one more question. Ms. Holmes, Rachel.
So I'm curious about privacy legislation in the United States and the European model and the GDPR. Those provisions have diffused to other countries globally. This creates some benefits for firms that have already adapted to the legislation. It's going to reduce transaction costs. So in the United States, do you foresee a movement towards adopting the GDPR in a lot of these provisions, and what might prevent that?
So there's a question of, there's a level of window dressing, there's a level of reality. Whatever legislation is adopted will be styled as being based either on California or GDPR. From a political standpoint, that is essential. What I would say is, I don't know what your experience is, but there is widespread dissatisfaction growing in Europe on GDPR. One is they treat all personally identifying information as suspect. So there's a routine function that internet people do called who is. If you get an address, who is the person that owns this internet address? That is illegal under GDPR. And they're having to put through a fix right now to exempt that. And there's lots of phone books could potentially be illegal. And these are all kind of silly. It's just the nature of the statute is problematic. The second thing that's sort of weird about it is it's still based on the notice and consent idea that has animated largely US law. It hasn't really changed my practice. I just blindly click accept a lot more often now than I used to. And I think there's somewhat of a dissatisfaction in how it's actually playing out in real fact, that it's not really doing very much. And so I think that GDPR is extremely unlikely to be the center of the discussions because people don't really think very much of it. What I think is the California legislation is much more influential, it's much more directly applicable in the US. And it's going to be the centerpiece of what we're talking about, but even that's really about onward transfer, what we call transfer of third parties. And that is a really, to my eyes, a 20-year-old obsolete perspective. You talk about Elizabeth Warren, her current legislation proposal, which is primarily for the campaign, is about onward transfer. And to me, they're missing the fundamental vote. The question is not who else is Facebook giving your data, it's what are they doing with it themselves. And that is really the basic point. Well, we reached the end of our time. I'm happy to say that Penn is the center for a lot of this stuff. We've talked about Elizabeth Warren. For those of you who don't know, she's a former member of this faculty. We talked about the slants. We had them perform here last year around this time, so we actually can't promise you we'd do that, but we didn't even get Renee to come and say the name of his company. But I hope that what we did provide was at least educational, useful to you. There is a reception outside. We invite you to come join us, and please join me in thanking the speakers for staying with us.